Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by LiveLaw. We bring to you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with an important piece of information. Bombay Lawyers Association has filed a public interest litigation petition before the Supreme Court seeking a cooling off period of 2 years before any retired judge of the Supreme Court or High Courts can accept a political appointment. This comes amid the mounting criticism over retired judges accepting post-retirement sinecures. The recent example being that of appointments of former Supreme Court Judge S. Abdul Nazir as Andhra Pradesh's governor. This led to a debate because of Justice Nazir's membership of the branches that delivered two crucial yet controversial Constitution bench judgments in the Babri Masjid Ram Janmabhoomi dispute and the challenge against the 2016 demonetization of high-value banknotes by the central government. Also, you must know that since 2014, Justice Nazir is the third such judge who, after retiring from the top court, received a high-profile appointment. Former Chief Justice P. Sathasivam was appointed as the Governor of Kerala within 5 months of demitting office. And Justice Ranjan Gogoi was nominated to the Rajya Sabha exactly 4 months after he retired from the Supreme Court. In the present petition, the petitioner states, though there may not be any actual quid pro quo between the judge receiving a post-retirement political position and the executive, but nevertheless, it erodes the public confidence in the independence of judiciary. The petition thus prays that there should be a 2-year-long cooling-off period after retirement, after which former judges of Supreme Court and High Courts may accept political appointments from the government. Do let us know about your thoughts on the same in the comment box below. The Supreme Court bench comprising Justice Bela Trivedi and Justice Prashant Kumar has remarked that it's impossible for anyone to expect luxury in jails. This was while hearing a plea filed by Harsh Dev Thakur seeking temporary bail in a case of financial fraud. The court was prompted to pass this comment after the counsel appearing for the petitioner pressed for relief. The counsel argued that the petitioner was not in luxury while being in jail and that it was impossible to arrange funds while he was detained. The court proceeded to dismiss the petition and ordered to expedite the trial. The petitioner was allowed to move the court if the trial would not be completed within a reasonable time period. In another update, the Supreme Court has sentenced a non-resident Indian to 6 months imprisonment and imposed a fine of Rs 25 lakhs for contempt of court for failing to bring back his minor son to India in terms of the orders passed by the top court from time to time and the undertaking given by him before the court to this effect. The bench of Justices Sanjay Kishan Kaul and Abhay S. Oak said that the contemner was under an obligation to bring back his minor son to India on 1st of July 2022. However, the conduct of the contemner showed that he never had any intention of bringing the child back to India. The bench found that the contemner had not shown any signs of remorse and that he had scant respect for the orders of the court. And now coming to the Delhi High Court, which today dismissed the bail plea of Aam Aadmi Party leader and former Deputy Chief Minister Manish Sisodia in the CBI case alleging corruption in implementation of excise policy for the year 2021-22. As you know that the court reserved the decision on May 11th and today Justice Dinesh Kumar Sharma pronounced the order, saying that Sisodia, being an influential person and having held the post of Deputy CM with various portfolios, and the witnesses mostly being public servants, the possibility of witnesses being influenced cannot be ruled out. Sisodia is currently in judicial custody in the cases registered by the CBI and the Enforcement Directorate. He was denied bail by the special judge in the CBI case on March 31st and was denied bail by the trial court in the ED case also on April 28th this year. In another update, the Karnataka High Court today, by way of interim relief, stayed the investigation against former Deputy CM of Karnataka and BJP MLA Dr. C.N. Ashwath Narayan for allegedly making a derogatory statement against now Chief Minister Siddaramaiah during an election rally in February. Narayan had approached the court seeking to quash the FIR registered against him under Section 506 of IPC, that is criminal intimidation, and Section 153, that is giving provocation with intent to cause riot. The complaint was made by M. Lakshman, who is associated with Karnataka Pradesh Congress Committee. A single judge bench of Justice M. Nagprasanna noted that the statements made by any person should be so provocative that it should result in writing, or even if it does not result in writing, it should be capable of resulting in writing. The bench said that no such incident had been narrated, as the statement was made in February and 3 months had already passed. The central government has notified the appointment of Justice Nitin Jamdar as Acting Chief Justice of Bombay High Court after Chief Justice R.D. Dhanuka demits office today. Justice Jamdar, after graduating from Government Law College, Mumbai, practiced at the Bombay High Court in diverse fields, primarily in administrative and constitutional law. He represented various public bodies and was also Senior Standing Counsel for the Union of India. In January 2012, he was appointed as a judge of the Bombay High Court. Justice Jamdar will take over from Chief Justice Dhanuka, who has had the shortest tenure of a Chief Justice for just 3 days. Chief Justice Dhanuka took oath on Sunday. His tenure lasted only for 3 days. The Delhi High Court today quashed the Bar Council of India's decision, which refused to consider a South Korean citizen as eligible for enrollment as an advocate with Bar Council of Delhi. The foreign national had moved to India with his parents at the age of 11 and lived here continuously till he graduated from Nalsar University in 2016. Justice Yashwant Verma directed the Bar Council of India to process the application of the petitioner in accordance with law. The Kerala High Court has held that details regarding the illness suffered by the proposer or person assured in a life insurance policy, the previous treatment administered to him including hospitalization and so on, which are raised as specific queries in the proposal form of the insurance company, are material facts, and in the event of any material suppression or furnishing of false information, the insurance company would be entitled to repudiate the policy. Justice Satish Nanan further went on to observe that it would not be open for the claimant to contend that someone else had filled the proposal form on his behalf, and so mentioning of the false particulars could not be attributed to him. In this case, the husband of the respondent had taken an insurance policy on his own life, with the wife as the nominee. Pursuant to his death, when the respondent raised the claim for the amount, the same was repudiated by the petitioner, alleging the furnishing of false information and suppression of material facts by the assured in the proposal regarding his health condition. Observing that women cannot be forced to choose between their right to education and right to exercise reproductive autonomy, the Delhi High Court has granted relief to a female candidate seeking relaxation of her attendance for completing M.Ed course after having been denied maternity leave. The court was hearing the plea of the woman seeking direction on University Grants Commission to frame specific rules and regulations for grant of maternity leave for postgraduate and undergraduate courses. She was enrolled in December 2021 in the Chaudhry Charan Singh University for pursuing 2 years M.Ed regular course. She filed an application for maternity leave before the concerned dean and vice-chancellor of the varsity, who rejected her request. Setting aside the decision of the varsity, Justice Purushendra Kumar Kaurav directed the university to consider her application for 59 days of maternity leave afresh against the theory classes. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can check the links given in the description box below. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us.